Hello, this is Matt on the Moon Family Sedan channel. I've got two topics to share with you in this latest Moon Family Sedan room temperature jam. The first story I'm going to cover comes from attorney Bill Morgan, who of course is a member of the XRP community. Now, Ripple has pivoted their XRP sales strategy, and that dates back, this May will be 3 years actually. But why did they pivot? Well, there's some additional in-depth insight shared by attorney Bill Morgan that I've been looking forward to sharing with you. And in a separate story that I finally got a little bit of time to look forward to, it actually was hot a couple days ago. It's on this topic of Sam Bankman-Fried potentially having bail revoked. But while that's interesting in and of itself, because I wouldn't mind that in the least, there's something strange going on, as pointed out by an attorney who is just participating on crypto Twitter. And what's happening in terms of SBF's treatment and protection, even from the prosecuting side, he just says it is not normal. And because the judge, I'll just tell you this at the outset of the video, the judge is just like kind of dumbfounded the way it comes across. He's like, but look at all of these things. Look at all of these things that he's done and how he's trying to engage in secretive communication. And what, he shouldn't have bail revoked? But the judge acknowledges it's actually still a possibility. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so this first topic I want to share with you got kicked off on Twitter by attorney Bill Morgan, member of the XRP community. And he tagged me along with some others in the community. So thank you very much, attorney Morgan, for tagging me. And I find his insight here to be rather thoughtful because honestly, the ideas that he has on this, I hadn't seen cited by anybody else. So check this out. The SEC states in its summary judgment motion memorandum of law that Ripple's counsel, Andrew Seresny, met with Hinman in September 2019 and was advised to register offerings of XRP or stop offering them. So let's pause to note, Andrew Seresny, that's one of Ripple's attorneys. Andrew Seresny formerly worked at the SEC. And so I'm sure most of you may recall that there are at least, I can't remember how many, at least a few attorneys at the upper echelons of the SEC who, upon leaving the SEC, went into private legal practice. And that's who Ripple hired, which is awesome in and of itself. And so you have former SEC official Andrew Seresny representing Ripple at that point and meeting with Bill Hinman in September of 2019. And at that point, Andrew Seresny was advised to register offerings of XRP or stop offering them. And then attorney Morgan continues. Excuse me. Up to that time, according to the SEC, Ripple had sold XRP in programmatic sales. So let's pause. Let me pause that too. I've never seen the actual definition of what programmatic sales are, and I've read every XRP markets report from Ripple. I think it's just every sale that isn't specifically directly related to on-demand liquidity transactions. It's anything else, any other potential firm. I don't know if that means it could have been a cryptocurrency exchange that's not engaging in on-demand liquidity, or a hedge fund that wants to invest. If there may have been stuff like that. I'm just making stuff up. I don't have specific examples, but I'm saying anything that's not on-demand liquidity. And so the programmatic sales had stopped here. So that's what Bill Morgan is citing here. So again, he says, up to that time, according to the SEC, Ripple had sold XRP in programmatic sales. The SEC alleges Ripple did not know who were on the other side of these programmatic blind bid/ask transactions. In any event, it seems Ripple stopped such sales in September of 2019. Was this connected to the September meeting with Hinman? Ripple alleges it has essentially only sold XRP to ODL customers since May of 2020. So this means we're talking about positioning XRP as a bridge currency purely for utility. So these are partners that are using it for a specific purpose, unquestionably not as some sort of investment, because it lasts for 2 to 5 seconds, okay, each transaction. So clearly not for investment purposes, which clearly disqualifies it from, satisfying the Howey test, meaning obviously if it's not satisfying the Howey test, not a securities transaction. And so he shared this screen grab from Ripple's attorneys, which reads as follows. Since May 2020, essentially all of Ripple's sales of XRP, with full disclosure to the SEC, have been to on-demand liquidity customers who have sourced XRP directly from Ripple for cross-border transactions. End quote. Attorney Morgan continues. Another means of sales were sales made to sophisticated institutional and accredited investors, which the SEC alleges Ripple knew was a conduit to resale to retail purchasers in public markets at a profit, and which did not use XRP as a currency. Let me just pause. It's right what he's saying, of course. But the allegations the SEC are making are complete and utter nonsense, because then, even if you're talking about the programmatic sales, you still get to this question of, like, even if those were in specific transactions that the SEC were trying to target, and even if they were literally in violation of the law, and I'm not ceding that point, I'm just saying even if, that doesn't change the fact that whoever received them from Ripple, sell it to whoever they want. That's secondary market sales, as the judge found in the SEC v. Library case. Secondary market transactions are not a piece of this. That has nothing to do with it. And if you go back to all case law dating back to the Howey test, go back to 1946, there are no court cases, zero, zip zilch nada, that found that that secondary market transactions were somehow in any way related or to be considered under any sort of ruling from any case law that had been set. So secondary market transactions, not a part of anything. It's settled law. In terms of precedent, it's set. But still, SEC be doing what SEC be doing. Attorney Morgan continues. The SEC alleges these sales continued to the end of 2020, although if Ripple is correct, there were no such sales that were not to on-demand liquidity customers after May of 2020. The SEC alleges these sales to on-demand liquidity customers were also conduits to public markets. The SEC is aware the on-demand liquidity transfers are quick and that the on-demand liquidity customers holds XRP for mere seconds. The questions I have are, number one, whether Ripple stopped sales other than to on-demand liquidity customers because of the September 2019 meeting with Hinman and the SEC investigation. So I'll pause to note that is an excellent question. And Attorney Morgan is the first person I've ever seen posit that question. And the timing is such that it makes you go, doesn't it? I mean, isn't it? It's very reasonable to speculate that meeting, Andrew Szczesny and Hinman, directly resulted in Ripple changing strategy. And up to that point, I imagine that they felt pretty good about what they were doing, especially after the Bill Hinman Ethereum Free Pass speech, in which he was talking about how decentralization of a blockchain would be a leading factor in determination of whether or not there was some sort of infringement when it came to securities laws. So Ripple probably feeling pretty good up to that point. And then Bill Hinman is like, says this thing that's just outside the scope of even his own damn speech, stupid ass speech in 2018. And then Ripple pivots right at that exact moment in time. Probably not coincidence. That'd be my for fun guess anyway. And then Bill Morgan says, so a second question here. What does this imply about Ripple's internal risk assessment about programmatic sales? Or sales to institutional investors who intended to resell for profit and not use an on-demand liquidity, given sales to on-demand liquidity customers aren't to customers who wish to invest. The SEC own memorandum of law admits they are held for mere seconds and who wish to exchange the XRP, which is consumptive. Number 3, is this why the SEC did not seek an injunction to stop Ripple's on-demand liquidity XRP sales continuing after the lawsuit started? Because it knows they cannot be investment contracts. Equals no investment of money, no expectation of profit, no common enterprise between on-demand liquidity customers and Ripple. Now pause. I hadn't heard that from anyone else either. But you can see once your brain starts going in that direction how all of it makes perfect sense. Because how many times have we all been sitting around asking, if what is being done is so wrong and so illegal, why has the SEC not sought an injunction to prevent Ripple from doing what they're doing and selling XRP? Well, the reason is because they know the injunction would fail. That's why. They know they're on the losing side of this damn thing. At least for that portion in terms of on-demand liquidity. So what? So if they know that they're going to lose on that, but maybe they're confident more so on the programmatic side, is there actually going to be some sort of penalty against Ripple, even if they did something wrong and illegal, that won't allow for the legal portion, which would be the on-demand liquidity sales? Don't you think? Like, duh. This is why I really appreciate the perspective here. It's just really thought-provoking. Anyway, so question number 4 from Attorney Morgan. What is the relevance of 2013 through 2017 sales compared to post-2017 sales? I keep seeing as determining the fine Ripple may be ordered to pay if it is unsuccessful. The analysis should perhaps focus on the type of sale, not when it happened. This again points to the rod the SEC made for its own back, trying to argue there is a single continuous offering and all sales of XRP are investment contracts, not focusing on specific sales or types of sales. So folks, pause a note here. This is another situation where their ridiculous argument, all-encompassing argument, which is clearly a tremendous overreach far beyond their jurisdiction. This is another instance where it looks like this, if we get a just ruling here, it's going to come back to bite them in all likelihood. It's another instance of why. And then Attorney Morgan says, cannot see that the SEC has explained how the category of sales to on-demand liquidity customers meets the Howey factors. And then number 5, is this why there is no settlement? Ripple wants to go back to institutions and programmatic sales, but these sales, not sales to on-demand liquidity customers, continue to be at risk. Now, that would be interesting. What if in the talks, and we're not privy to this, but what if, I don't know the probability of this, but what if the SEC would have been able to seed the point, like the backroom communications, seed, okay, you can do on-demand liquidity, but not programmatic, and then for Ripple, that's a hard no, because they want to be able to do both. I don't know. I don't know how much is going to come out in the coming, weeks, months, and years ahead, in terms of, stuff that, we typically wouldn't be privy to. But at least at the minimum, obviously, everything's going to be fully transparent in terms of the judgment coming down from Judge Annalisa Torres in terms of the rationale for whatever conclusion she comes to. At least we're going to be privy to all of that. Interesting stuff indeed. So, Attorney Bill Morgan, thank you very much for tagging me. I appreciate the thoughtful thread here. Now, on to the next topic, and I'm going to try to be brief on this one, but it's covered all over crypto media and mainstream media. This one's from Yahoo Finance. Judge warns FTX's Bankman-Fried, your freedom can be revoked. And so I came across this from a lawyer on crypto Twitter here, Meta Lawman, who had the following to say about this article, which I'll touch on. He said, prosecutors continue to argue against sending SBF to jail, even though the judge believes, quote, there is probable cause he attempted to commit a felony while on pretrial release, end quote. This is not normal. Folks, did y'all hear that? Prosecutors are arguing against sending SBF to jail, while the judge is like, okay, but he might have committed a felony. What? Are you kidding me? This is wacky stuff. So I was like, okay, I got to cover this. Former FTX CEO Sam Bankman-Fried's freedom was on the line during a court hearing on Thursday as government attorneys and lawyers for the indicted crypto entrepreneur argued over further restricting his access to electronic communication. During a hearing in Manhattan Federal District Court, following weeks of negotiation between the parties, U.S. District Court Judge Lewis Kaplan tabled a decision on the prosecution's request to cut off Bankman-Fried's internet access and continued to express skepticism over the defendant's access to encrypted communication services. It isn't clear when Judge Kaplan will rule on the request or why he afforded the lawyers more time to work out the dispute, though the extended Bankman-Fried's bail conditions ordered on Wednesday. He asked Bankman-Fried's lawyers to consider hiring a technology guru who could provide the court with device monitoring expertise and asked that the defendant be prepared to address his lingering concerns by February 24th. Quote, why am I being asked to turn him loose on this garden of devices, end quote, Judge Kaplan asked during the hearing, during which U.S. Assistant Attorney Nicholas Roos proposed cutting off Bankman-Fried's cell phone, tablet, and computer access as well as his access to smart TVs and online video games. In essence, the government argued that Bankman-Fried should be prohibited from accessing the internet in order to allay concerns that he may use self-deleting messaging apps and virtual private networks, or VPNs, to communicate with potential trial witnesses. Following his arrest, Bankman-Fried messaged the FTX US General Counsel over Signal and email, as well as other current and former FTX employees. He later used a VPN on January 12th, which his lawyers contend was to view the Super Bowl. Quote, "We are dealing with somebody who has done things that show there is probable cause he attempted to commit a felony while on pretrial release," end quote. And that's from Judge Kaplan. But he just gets to continue to be out on bail, huh? Well, maybe not. We'll see. We'll see what the judge says, but it's just so freaking wacky. I just wanted to at least spend a couple minutes just sharing this with you in case you miss it. So, is what it is, folks. Everything in crypto is weird and crazy, though. Whatever. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.